Ooh, I'm scared. The answer to your question is yes, anybody can be charged with anything they want to charge you with. The notary public was actually a friend of my friend, but he was just learning this process. And he was exercising his duty as a notary to literally affirm the affiant's signature on affidavits and to issue certificates of protest, which in the notary book is exactly what they're supposed to do if someone comes in with facts and evidence of those dishonors. So he was doing his job. Now, they arrested everybody, threw them in jail. They're a little bit serious. They don't like people that are learning how to do this stuff. And of course, these people are attacking the land taxes too, and they really don't like people attacking any taxes, but the land taxes are very sacred. And you can't convince the majority of these patriots that since we're all standing on the deck of the Titanic, there is no soil to protect. The best thing you can have in your possession when you're on the deck of the Titanic is a copy of the deed to the soil, which is off on the land someplace. And what they want you to do is deposit your deed in the purser's safe while you're riding on the Titanic. And when they dock, if they ever dock, they'll give you the deed back so that you can take it back to the soil and make your claim if there's ever any land that appears again. So coming out and claiming an allodium and whatever is kind of silly in the maritime world that they created. So here is this public notary, and he's in jail with these major felony charges. Now, we were assuming and presuming maybe under state statutes it may take 3 or more persons to be charged with a racketeering corrupt influence. I heard some people tell me that under Fed it may take 5 or more. Under state statutes we're presuming it may take 3 or more, which is probably why they gigged the notary public, because it was kind of stretching it to accuse him of extortionate activity trying to get this land to which he never expressed any interest. But nevertheless, they can do anything they want, and they may have needed him or whatever, so they poured him into the bunch. Well, before a couple of days were over, the original bail bond for the notary public was $100,000 cash. The bail bond for the second person was $100,000 cash, and the bail bond for the first person, my friend, is $1 million cash. We're not talking about an actual murder or mayhem here. We're just talking about the civil issue of who does or doesn't owe taxes and has a title on this land. So you can see they get upset very easily or impressed very easily. And after the original hearings, they decided that they would reduce the bail bond of the notary down to $10,000, and he could post, now it was $10,000, and he could post 10% and go. They reduced the bail bond of the second party down to $25,000 cash and kept the bail bond of the first party at $1 million. Now, for some reason, a lot of the people up in Michigan started contacting me because the first guy has been getting the Monday night tapes for a long time. I've known him. He's been doing a lot of legal procedures for probably 20, 25 years. He's not wet behind the ear at this, and he has called a couple of times from jail to talk to me. And so he's got people on the outside up there assisting him, but I guess he told them, see what Jack has to say. So I've talked to a bunch of people, And they were all particularly for the notary public, who really, other than the fact that he's a public notary and he's heard some of the things that these people have talked about. And at first it sounded pretty good. As soon as they jailed him on a felony for being associated with people that used it, this public notary's wife immediately went hyper and said, "Don't you do any of that stuff ever again, because it got you in trouble already. It isn't working," quote unquote, "and therefore just go with what the attorney says, and he'll get you out of this because you're innocent, and you'll have all the evidence to prove that." Okay, wish I had a buck for every time I heard a patriot or anyone else say that. But anyway, some of the people up there said, "Is there any kind of paperwork that you could recommend for any of this stuff?" And I said, well, it would kind of be nice if the public notary understood the concept under the common law of confession and avoidance. Not that there's any common law out there, but admiralty pleading is an offshoot of the common law plea of confession and avoidance. The confession is the acceptance of the facts in the charging instrument, and the return and the ask for closure and settlement. And the avoidance is where, as part of the common law plea, you bring in extra facts that were never in the pleading that charged you. And the extra facts always end up changing the whole issue of law, so that under the substantive side of the accusation, their conclusions of law are rebutted and disappear, and you're no longer presumed to be the evil Adolf Hitler or Saddam Hussein. You're now the nice guy that just got trapped in a big mistake. So what you need to understand is confession and avoidance. And they said, well, how do you do that? And I said, well, the confession, you just accept the charging instrument right across the face of it and return it back with the magic words on it and tell them to close and settle the account by way of offset and adjustment. They're going to use your exemption, which is the straw man's Social Security number, which we don't call the SSN. It's the EIN, which is the exempt identification number without the dashes. And that's your confession. Now you got to do your avoidance, and that is to file a negative averment, an affidavit stating the extra facts in the negative, because nobody can be compelled to prove a negative, but it rebuts the presumption of the facts, or actually rebuts the presumption of the conclusions of law, which are stated in the charging instrument. So I said this ought to be fun for the public notary, because he was just doing his job. He has no interest in the land and the property, and so we could rebut those in a heartbeat. And so I said, I'm not telling you what to do. All I'm telling you is if it were me, I'd do something like this. So in the negative averment, we said, comes now, guy's name, you're affiant, who after having been first duly sworn, states the following. 1, that your affiant is, his name, who is over the age of 21, competent to testify. 2, that the statements herein are true, correct, complete, and certain of first-hand knowledge. 3, that your affiant has seen an instrument entitled Warrant Felony in State of Michigan, then with the caption of the court and the court name and the court case cited on there. 4, that your affiant has no financial interest or financial gain and expects no financial interest or financial gain as a result of any contacts with, then he names all of the people who are supposedly the victims of this scam. So he's denying he has any financial interest with those people. Remember, what did I read in the count of the charging instrument? Let me read it again. Listen for the facts. Criminal enterprise, conducting. Being a person employed by or associated with an enterprise, to wit, a group of persons associated in fact did knowingly conduct or participate in the affairs of the enterprise directly or indirectly through a pattern of racketeering activity consisting of two or more of the following incidents of racketeering, to wit. Is there any facts in there yet? The only facts is we need two or more people. No, it didn't even say that. We need a persons employed by or associated with an enterprise. So we need an enterprise and we need persons, and they have to be employed. Okay. On or about November 2001 through April 2003, in a certain county, defendant did attempt to commit the following offense for financial gain. To wit, did maliciously threaten to injure the property of blank, one of the people, with intent thereby to extort money or any pecuniary advantage whatever, or to compel the person so threatened to do or refrain from doing an act against his or her will, contrary to a state statute. What facts in there? Dates. That's fact. No, during the time, it's date. That's stated fact. During this period of time, it's not a date certain. It's a range of dates, okay, in a particular county. That county is a place. It's a fact within a state. Did commit the following offense. Conclusion of law. It's not fact. For financial gain. Conclusion of law. To wit, did maliciously threaten. Conclusion of law. To injure. Conclusion of law. The property of such and such. Such and such is the name of a person, so that's a fact. With intent thereby to extort money. Conclusion of law. Or any pecuniary advantage whatever. Conclusion of law. Or to compel the person so threatened. Conclusion of law. To do or refrain from doing an act against his or her will. Conclusion of law. Contrary to such and such statute. A fact. So the only facts we really have here is the presumption there was an enterprise. We don't know what that was. And they presumptively say the defendant was a party to it. That's a conclusion of law. So we know the name of the victim. We know the dates of the so-called enterprise, at least a range. And we know a territory where the so-called presumptive acts were committed. And we know the name of the party upon whom they were allegedly permitted. Other than that, it's all conclusions of law. So is there anything in here that we want to dispute? We don't want to dispute any facts. All the facts in this charging instrument are true. The only thing we have to concern ourselves about is rebutting the presumptions. But see, when you are asked to plead to a charging instrument, all you're asked to do is accept whether the facts therein are true or not. And if you plead not guilty, you're saying you don't agree with the facts. But we all just sat here and read this charging instrument, and we all just made the same conclusion that there's no facts to get upset about. They did a perfect job of bringing about a complaint in which none of the facts are wrong in this charging instrument. So why would you want to plead not guilty? If you pled not guilty to the name of the victim, what are you arguing that victim isn't involved in making a claim here or charge? Are you arguing that the dates were improper, that they're claiming the event happened? Are you arguing it didn't happen in the fixed location that they said in the complaint? Everything else is a conclusion of law. Now, because you listened to the conclusions of law, you presumed you had to plead not guilty, otherwise you're in big trouble. Because you didn't like the conclusions of law. No problem. The facts in this thing are perfect. I'd plead guilty to the facts every time they brought that to me. Now, he comes out and he says, in his affidavit, that he had no financial interest or financial gain and expects none as a result of any contacts that he had with any of the people mentioned in the charging instrument. What did he just do? Rebutted the presumption that, well, if he was a member of an enterprise and a racketeering organization, he was in it for the fun, not the gain. I wasn't doing it to get any money out of these people. Is this a commercial court or a court that deals with, like the song goes, he was charged with having too much fun? And that's now illegal, okay? Or was it that you're charged with the violation of a commercial activity? And if there's a commercial activity, remember it said in the charging instrument that the presumption was that it was being done to extort money or any pecuniary advantage whatsoever for financial gain. He just negated the financial gain presumption by his affidavit. Next point, that your affiant has never threatened to injure nor has injured any property belonging to all those people. Remember, wasn't that one of the conclusions of the law, that you were doing it to threaten to injure property? 6, that your affiant has never been a party to any enterprise or association or group of persons for the purpose of conducting any extortion of money from those people. 7, that your affiant has not been a party to any enterprise or association or group of persons for the purpose of compelling those people to do or to refrain from doing an act against his or her own will. When you're involved in this administrative process, and they're going to attempt to charge you with this, just because they don't like that you're conducting all your legal issues privately instead of hiring an attorney publicly. See, the problem that they're having is it's got to be done to exact something against their own will. Now, when all of this administrative process is sent out to these people, aren't you soliciting them to respond and resolve this issue peacefully by responding? So what is it that you're doing against their will? Is it their will that they don't want to resolve the case so they won't respond to you? Is that what you're forcing them to do? Because that runs against the whole presumption of the private administrative process. You send them a letter and say, hey, brother, help me resolve this, and they stand silent. How did you get them to act against their will? Did you run over to the house when the letter arrived and gag them and tie up their hands so they couldn't respond? Is that what you did that was against their free will? Why didn't they just write me a letter? Why didn't they just respond? Are you telling me that I prevented them from answering my inquiry? Is that how they acted against their free will? They had free will to write a letter. They had free will to hire an attorney to resolve this for them. They had free will to do a bunch of stuff until the process of certificate of protest from the notary public reached their door and told them, I guess you guys have given up. You didn't exercise your free will. Therefore, you lose. See, they're charging these people criminally with doing what those people didn't exercise their free will, and now they're coming back on these people for evidently taking away their free will because they wouldn't resolve it. They're calling the kettle black. 8, that your affiant has not acted in any capacity with regard to those people other than as a witness and a public notary on documents brought to your affiant by, and then he names the other 2 people that have been charged in this process. See, he's just the messenger. Don't shoot the messenger. 9, that your affiant does not believe that it is a criminal activity to witness as a licensed public notary the signatures and oaths of third parties and to execute documents as a witness to the facts averred to by third parties thereon. Man, if you want to start charging public notaries for crimes for doing their job, I think they're all going to resign en masse. 10, that your affiant is not personally involved in the commercial affairs of, and then he names the other 2 parties that have been charged. Further, your affiant saith not. What has this guy with his affidavit just done to the charging instrument? Rebutted all the presumptions of conclusions of law, and he did it by an affidavit of negative averment. Since they're negative, he isn't testifying to the merits of the case, so he hasn't lowered himself to be the debtor in the procedure with respect to those matters. So he's rebutted the presumption, and the judge ought to go, okay, prosecutor, have you got any evidence now to rebut the public notary's affidavit that said he was just doing his job? Because if you have no facts that you're going to allege, we should really dismiss this guy out of here. He ought to be gone. Now, did he go in and argue the facts in the charging instrument? No, there's nothing to argue. Every time they charge somebody in a charging instrument, the facts are always true. Unless they really flunked out of law school and didn't know how to draw up a charging instrument. And I'm not going to say there aren't some lawyers that probably won't screw that up and do it wrong. But if they're as smart as they're supposed to be, then they won't screw up the procedure of drawing up the complaint. Now, what happened is I did that, and then I put together a letter rogatory for the guy. Now, a letter rogatory is a private letter to the attorney. What attorney? Well, you see at this first hearing there, the judge appointed him a public pretender. And it was absolutely necessary because there's all kinds of court case law that says that if a guy hasn't got counsel during the legal proceedings, you cannot put him in jail. So since the goal is to put him in jail because then they'll sell a bond on him and sell a bond to bankers to gain money for the county and the state and the city, which is how they pay their people and build their government. Since they sell that bond, then whoever buys that bond has a lien upon the guy, the defendant, who screwed up, and the defendant goes to jail under a common law indentured servant rule until the money to the guy that bought the judgment is paid back. Because obviously the defendant owes the guy who paid his crime, i.e. bought the judgment from the court. Walmart's good at doing that. And then you all go to jail until you either pay back the guy who bought your judgment and paid your debts for you, which the city, county, or state or feds keep so that they can build bigger and better governments to deal with us, or until the time is up and expired, whereby under the law you have to be discharged and the debt's forgiven. So the letter rogatory is written to the attorney that they appointed to help this guy because they need to have given him an attorney so he's got counsel. And if the guy is stupid enough to dishonor the court and reject the counsel, it won't faze them at all. They'll smile deeply inside. They don't want it to show, lest you figure out you screwed up and immediately beg to get him back again. And they will just say, well, he'll be there for standby so that you've got counsel whether you want him or not. And since he's standby for the whole case, you've had your counsel. You can appeal it later on and argue you didn't get the counsel of your choice. But then, as they say in the Matrix, so you think it's all about choices, do you? A choice is what the person going to the scaffold to be hung has. He can fight his way up to the scaffold or he can go peacefully. He's got all kinds of choices. So in any event, I decided that maybe to help suggest to these people what they ought to do, I'd put together a letter rogatory for him. So he's got his name and address, upper and lower case on the upper left like a business letter, and the caption of the letter is letter rogatory. And the date that he mailed off his business letter, and it's addressed to the all uppercase lawyer, because the lawyer is a title of nobility in a fiction which deals in their fiction court, so they kind of go together. And they got the address of the lawyer's firm, and then under that, the acceptance of appointment of counsel and request for services and case number. And then we got the case down. Dear sir, please be advised that I humbly accept your appointment as per the court appointment in the state of Michigan, such court, such case, such county, etc. I request that you perform the following on behalf of the undersigned. Number one, do not argue any facts on the public side of the above matter in behalf of the undersigned. There's no facts to argue, is there? They're all true. Two, represent the undersigned only on the private side of the matter as per my directions. Three, secure for the undersigned a personal appearance bond or personal recognizance bond without any public charge and without public fees or costs so that I can plead to the charging instrument as my remedy. 4. It is my intent to plead guilty to the facts in the charging instrument and not to controvert any of the well-pled facts therein, which are all true. 5. In return, I request that this court discharge the appearance bond to the undersigned at the termination and close and settle this matter. 6. I also request that any and all public and private costs, fees, charges, and restitution that might come out of this court as any orders in this matter be discharged by exchange of my exemption for settlement and closure, which I hereby authorize under exemption number and then his SSN. 7. I request that any and all charging instruments in this matter affecting the undersigned be accepted by you for and in behalf of the undersigned and returned to this court for settlement and closure forthwith. If my signature is required on the acceptance, I request that these instruments be delivered to me forthwith for my signature. I request that these instruments be filed by you on the public side of this court's record then. See, doesn't the founding documents say that all of us are in fact born equal? Doesn't that mean we're all sovereign? It's just that most of us sovereigns don't know how a sovereign acts, so we lose it immediately by acting stupid. Kind of like Nemo, who didn't listen to his father, the prodigal son, and got lost into the world of slavery. And so if we were born sovereign, then isn't all of our commercial affairs basically come out of our court, because we're sovereign. We must have a court to deal with them, right? So we are the operator of our own court, aren't we? And some foreign court charged the sovereign with something going on in their kingdom, in violation of their commercial laws. And in their commercial territory, in their court, they have someone in that court that's going to operate their court to adjudicate the commercial matters over in their kingdom, that foreign land. So, I am not a member of their foreign court or their kingdom. I'm a member of my own kingdom. Therefore, I have nothing to do with their court. Why would I go charging into their court, parading around trying to do a bunch of stuff? It's not my court. So I'd want to write a private letter rogatory of instructions from my court to an official of their court to try to have that official in their court try to resolve whatever problem is going on over in their kingdom, their land, and their court with regard to what they think the person out of my kingdom has done that screwed them up. So I write a private letter rogatory from my court to one of their officials that will negotiate with their foreign land and their foreign kingdom to help resolve this matter. Because if I go charging in there, I'm in a trespass in a foreign court. Now, the crazy judge of that foreign court actually is a very nice fellow. He appointed a negotiator so that my court can negotiate with their kingdom to resolve this matter. And he's called the defense attorney. And when they appointed this guy, then what I need to do is I need to understand that that was an honorable act by appointing that agent, that ambassador from their land and from their kingdom to come over to my court and try to resolve this common matter. And I shouldn't be particularly ticking this guy off since he's a foreign ambassador who they politely and honorably gave to me to help resolve this matter. Otherwise, I've committed an act of aggression on the ambassador at the peace treaty before we even resolved the issues and even heard the issues, which probably isn't off to a really good start. So what this letter is here is this letter is a letter from you because you are the operator of your court. You're sovereign. And you're writing a letter to the ambassador that they ascribe to you to meet with to try to negotiate a resolution of the problem between the two nations, the two sovereigns. So that's exactly what I'm doing here. I'm helping them understand that they got to write a letter to this ambassador to help them resolve these issues. Peacefully, we hope. And so we got down here to the end, and I request that any other service that you perform for the undersigned in this matter be approved by the undersigned before said performance be undertaken. With sincerest appreciation, and then he signed his name, comma, upper and lower case, offender and agent for defendant. Now, he says attached to the bottom of this letter rogatory are enclosures, which included an original copy of the affidavit of negative averment, which we just went through, which rebutted the presumption that this foreign here came into your land to mess around with your servants, slaves, and citizens. And then down at the bottom of that, we said that we're sending copies of this private letter to the prosecuting attorney in your foreign tribunal, the clerk of the courts in your foreign tribunal, and the judge in your foreign tribunal out of courtesy so that they will know what I have told the ambassador and the agent to do. It's a private letter. It isn't a secret letter. But if you want to believe the bullcrap these people will tell you, it's, oh no, I'm your attorney, and whatever you tell me is confidential. Nobody can drag any of our conversations between us out of us. If they do, it's a violation of their statutes and they're in big trouble. Excuse me, I want them to know what I told the ambassador to do. Because I think this ambassador's got his own agenda. And I don't want the ambassador being a turncoat on me. This ambassador works for a foreign country, and I don't know how that country works, and I don't want him misrepresenting my communications to his principals. There's nothing to be confidential, because you're in one of two circumstances. Either you injured the parties coming after you, and the only way to resolve it is admit that you screwed up and go ahead and compensate them for the injury and ask forgiveness. In which case, why are you going to hide your apology? You want it to be made to everyone. Or the other alternative is, presumptively, you have been brought in accused of something that substantively you're not guilty of. And you have nothing to hide with your attorney. The only time you have to hide behind your attorney is when you're guilty and you want to avoid and evade the responsibility of being honorable and doing it right. So there is absolutely no reason to keep your communications confidential. Now I'm going to tell you the funny events that happened once these documents went down. Lee.
In addition to those documents, or in that letter rogatory, you have to perfect service, so a certificate of service indicating that you attest to all these people being properly served, and then send everything out by certificate of mailing is the perfection you need so that it is not done in secret. It is done in private.
That's really kind of neat, but beep, in this case, it doesn't apply. Why? Because once you have the attorney, you can't do anything on the public side anymore. You're incompetent. So who does all that for you? The attorney. Remember in the letter rogatory I said I want you to do this. Okay? Now the only thing that you give the attorney to do is stuff on the public side. You never give the attorney anything to do on the private side because he won't do it most of the time. Okay? Now, what happened is I shared this paperwork up there, and it immediately went to people that didn't have a clue what it meant, what it said, and what was going on. All they knew was monkey see, monkey do. Oh, it came in. It looks pretty good. We haven't got anything else. He's going into a hearing tomorrow. Let's type it up into our computer. Let's get him to notarize it or get it notarized for his affidavit signed, and he can pack it along with him as he goes running to court in the morning. So he goes running to court in the morning and he sees his public defender, and he goes up to his public defender and he says, I got some things for you to do. And the attorney goes, oh, cool. What you got? He says, well, here's an affidavit of negative vermin. And it was the original, because you got to give the attorney the original because he's got to file it on the public side. And if it's not an original, the court will never file it on the public side. And then he would also have to do service in order to perfect the filing, but he's an attorney. He's supposed to know how to do filings and perfect service. You told him, do it on the public side. I'm not going to tell you how to do your job. That's what you went 50 years to school for. So go ahead and do it. So he shows the attorney the affidavit of negative averment, and I mean, you know, this is really long. Here's the first page, and here's the second page, and, you know, with the jurat, it's less than 1 page of kind of loose typing. So it's not really long. So the attorney goes through that, and he goes, golly, this is very good. He said, this is great stuff. I'll just keep this. I don't think it's going so well yet, but let's see where it goes from there. And then he said, oh, by the way, he said, here's a letter to you and the other copies to be mailed out to the other people. So instead of him sending copies of the letter rogatory to the clerk, the judge, and the prosecutor, he just gives everything to his attorney, and the attorney goes, what's this? And so, you know, this is really long. Here it's all the first page and half the second page, not including the CCs and stuff at the bottom. So it's not long. And he goes through the letter rogatory and he looks up at this guy. And the attorney said about 3 things. First thing he said is, this is the best description I have ever seen of this process. What did that attorney just say to his client? This is a letter rogatory. He was just told, don't go in and plead not guilty, don't argue the facts, help me out, help me get the bond so we can get settlement and closure and I can go home and resolve this. And he goes, this is the best description I've ever seen of this process. So concisely written. Now let me ask you a question. Do you really believe that all or even some attorneys are ignorant? This attorney didn't say, what in the hell are you getting at here? But you see, this guy surprised the attorney. He just handed him the piece of paper and they're on their way into the court. So it's kind of like a surprised utterance, whereas had he mailed this to the attorney 3 days ago, the attorney would go, oh my God, what are we going to do with this puppy now? So then, this public notary looks at the attorney after the attorney told him that, and he says the following to the attorney. This is where it gets to be fun. He said, well, I don't understand what was in that paperwork. Don't you just love to help people? It only gets better all the time. You give them a thermonuclear weapon to go to war against biologicals, and what they do is they hand it over to the terrorist so that now he's got a biological and a thermonuclear weapon to deal with you. So the attorney looks at him when he said, I don't really understand what was in the paperwork I just gave you. And the attorney says to him, they may have to put a bond on me if this doesn't work. What? Wait a minute. Who's got the liability here? The defendant supposedly had the liability. This guy says, I want to be honorable, let's just do settlement, and I've given you the affidavit to show you that I'm not involved in the substance of the crime. I'm not a bad guy. Now go in there and do your job. So what did the attorney do? He handed him back the letter rogatories and the copies, and he said, you know something? What you're going to have to do in this case is you're going to have to separate yourself from those two rabble-rouser co-defendants of yours, those patriot types that are fighting taxes. Because they're the bad guys, and I can see you're not the bad guy. You got to separate yourself from those guys. And if I were you, I'd take these back and rip them up. And he handed the letter rogatories back to our public notary. And he goes, oh, okay. And he took the documents back. And the attorneys got the original affidavit of negative averment in his pocket. And then the attorney says, well, I'll go in and see what they're going to do in the court today. So he left his client and went and ratted him out, undoubtedly. Needless to say, they did not have a hearing that morning. Gee, I wonder why. Well, not according to their straight face when his attorney came out to see him and goes, well,